sticks, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I'm joined today by not only the illustrious professor of law at Chase Law School, Ken Katkin, I am also joined by one of my own colleagues, Emily Smith, a historian here at Oklahoma Christian University. Ken, Emily, welcome to The Politics Guys.
Thanks, Trey.
Thank you.
Well, it's fun. We don't often get to do three shows. So, Emily, welcome to The Politics Guys. And for listeners, Emily is a historian here at Oklahoma Christian University. And her focus really, and one of the things I know listeners are curious about, Ken and I tend to do more international work, right? It's civil debate on American politics and policy, but Ken and I, we like to push the boundaries of that definition, right? And take things into the international realm, because that's actually your historical expertise, isn't it, Emily?
Yes. Yep. I mainly focus on Europe and specifically Ireland and women.
Hey, it all works out. So for the show today, we've got a lot of domestic, but maybe even some minor international things going on. We're going to start by taking a look at the Supreme Court and gerrymandering. We're going to move on from there and talk about the brouhaha over the National Archives and Trump and what he had at his estate in Florida. We're going to talk about the possibility of ending stock trading for members of Congress, what's happening there, maybe even more. We'll talk about the Open Markets Act, which is a bill coming forward on device platforms. Then we'll talk about trucker protests and a potential party identification shift occurring in the United States. So we got a lot of things. Obviously, not all of that's going to be on the preview, but we'll get through what we get through, and everything else will be on the full version of the show that is available to those of you who are listeners. But before we get that, we're going to have a brief break, and then we will be right back. Well, welcome back. So the first story that we're going to tackle this week is the Supreme Court. The Supreme Court this week struck down a lower court's emergency injunction against an Alabama electoral map that it was claimed to be in violation of the Voting Rights Act. Now, the 5-4 opinion is not a ruling on the merits of the case, but rather to send the case through the normal process and not allow the lower case stay. So this has been framed by many to be kind of an assault, or maybe the opening salvo on an assault on the Voting Rights Act. Now, the merit issue is relatively straightforward. Does the Voting Rights Act require a second majority minority district in Alabama? And then secondarily, if they do that, would it violate the Equal Protection Clause? Now, the primary arguments, again, this was not a ruling on the merits, came from Kavanaugh, with a concurrence then and then a dissent coming from Roberts and Keegan, who was joined by a couple of other of her colleagues. Now, both of them, though, do hint, and in some cases state, what they think might be happening on the merits, even though that's not the meat of the case. On the merits, Kavanaugh argues, he calls the issue, quote, unclear and confusing, end quote, which is why he doesn't think that the timeline should be an emergency one. No party is a clear winner in his view. And as to the stay, Kavanaugh argues that the case has nothing to do with the Voting Rights Act or the shadow docket, as he calls it, in response to Kagan's dissent, but rather is simply to stay on the injunction because the law is, well, the election's coming up too soon. And currently election law precedent says, look, we don't interfere as a court system with state elections if we're too close to a state election. And the fact that the beginning of early voting is here in 7 weeks, this would make it chaos in Alabama, according to Kavanaugh. Roberts went on to argue that the court rightly put the injunction in, and they shouldn't overturn it. There was nothing that happened at the at the appeal level here that should have changed it. He didn't want an emergency case, but he didn't think that the court should institute the stay, which is what the five majority had. Kagan, joined with Breyer and Sotomayor, argued by granting the stay against the evidence of the lower court, they're actually creating a merit level issue. They're forcing black Alabamans to suffer, and under that law is a clear vote delusion, end quote. So Kagan calls that the stay part of what she calls the shadow docket, something that's come around a number of times. Now, obviously, it's not just in Alabama. Florida has some issues going on with districts. South Carolina's had some issues going on with districts. But of course, this is maybe the centralized issue here. So, Ken, I'm going to start with you. What do you think about the again, not the legal ruling, but the merits on this stay, and then what we're getting hints of on the merits itself based on the concurrence and dissents?
Well, I consider this court to be a partisan and lawless court, and especially so in cases that involve election law and voting rights. And they outdid themselves this time in terms of the raw partisanship and the total lawlessness of this decision. I mean, this is a situation where there's already Supreme Court precedents directly on point about districting in Alabama under the Voting Rights Act, and those precedents more or less require the result that the three-judge district court reached in Alabama. And by the way, this is a three-judge district court that did a full fact-finding proceeding, and where 2 out of 3 of the judges were Trump appointees. And
it was a unanimous decision.
Unanimous decision. One of the judges was a Democrat, but my point is that 2 out of 3 of the judges were recent Republican Trump appointees, and they were all unanimous. That there was no dispute that under the existing standards from the existing Supreme Court precedents as applied to the facts of the case, there obviously must be a second majority minority district in Alabama, because Alabama is 27% black. It has 8 congressional districts, and under the Voting Rights Act, that means that in at least a quarter of those districts, to reflect the population, African Americans have to have some opportunity to have their votes be weighted as significantly as white people. That's what the Voting Rights Act calls for. So
now, what about the argument from Kavanaugh and from Roberts? Because I don't think it's surprising. We've had, as a matter of fact, the last time it was surprising was when you were kind of surprised in the opposite direction by the court's finding, right? Right. But in this case, to say the precedent of, well, it's too close to the election to change it.
No, that's ridiculous. It's not too close to the election to change it. It's true that there's a line of cases which the Supreme Court, which the majority here is greatly distorting, that says that the federal courts shouldn't change the rules too close to an election. But there's never been a case before where that was ever applied before the beginning of voting. There's an election every 2 years. So what the Supreme Court is saying here is you can never have a voting rights case decided in an even-numbered year, or in fact, you can never have a voting rights case decided until the illegal racial gerrymander has actually been allowed to be used at least once. And the court has never had any rule like that before. And the federal district court, again, the 3-judge court that included 2 Trump appointees, they addressed that question in their opinion, and they noted that there were 11 maps that had been submitted in evidence in the trial that would have been acceptable, and they gave the Alabama legislature 2 weeks, which would have ended yesterday if the Supreme Court hadn't intervened. So by yesterday, the lower court decision said the Alabama legislature had the opportunity to choose one of those 11 maps, which are already right in front of them, or to try to come up with a different one which could pass muster. And if that hadn't happened by yesterday, then today the court would have chose one of them. So this would have been implemented by today. That's before any primary voting or regular voting begins, and that's plenty on time to not run afoul of the court's rule that federal courts shouldn't intervene late in an election cycle. It actually, they're making a rule that automatically means no matter how illegally, racially gerrymandered a state's legislative map is, it gets to go into effect at least once before a court can look at it.
So now, again, you're the lawyer, I'm the political scientist, and you even started by saying that you find the high court to have to be a partisan one. So one of my questions as I thought about this in terms of politics was to ask and say, well, the appellate court actually had, as you've pointed out, I was getting ready, but you beat me to it. Two Republicans were on the unanimous decision. What do you think explains the difference between the ruling at that appellate level and the Supreme Court? Like, in other words, so if it's just a partisan issue, why don't we see that partisanship going down the appellate chain? Let's put it that way, and not just at the Supreme Court level.
Well, it's because the judiciary is hierarchical, right? So the lower courts have to follow the existing precedent, and the existing precedent is super clear on this. So all the lower courts had to follow that. The Supreme Court doesn't have to adhere to its own precedents; it can change its own precedents. So I think what the five Republican justices, other than Chief Justice Roberts, are saying is, we know we're going to change the law here. We're going to gut the very last provision of the Voting Rights Act that we haven't already gutted, and we're going to greenlight all racial gerrymandering against African Americans. We know we're going to do that on the merits. So since we're going to do that when we decide this case next year, why should we let a fair election take place this year? Because they have the privilege of knowing that they're going to change the law again, but lower courts don't have that. Lower courts just have to follow the law as it stands.
So then in that case, why not just make the case an emergency case and issue the opinion?
Well, because they would be constrained by the fact finding that was done in the trial court. Also, the lower court here, I should explain too. This is an unusual kind of proceeding because in a typical situation of most cases that come to the Supreme Court, the way they get there is you have a trial in a trial court, usually a federal trial court, sometimes a state trial court, and then you have an appeal to a U.S. Court of Appeals or a state Supreme Court, which is a appellate proceeding with a panel of judges, and then you have from there it goes up to the U.S. Supreme Court. But because the Voting Rights Act contemplates this timing problem that we've been talking about, that everything's always going to be in a hurry, it has special procedures that short circuit that. So instead of having a trial and then having an appeal to an appellate court and then having an appeal to the Supreme Court, the trial and the appeal, the trial and the first appeal are combined into one proceeding. So you have a three-judge trial court that does the fact-finding and the interpretation of law, and then that goes straight to the Supreme Court so that things move faster. So in this case, the trial court had a trial and it found a lot of facts. And under the Supreme Court doesn't have a trial proceeding of its own, so normal judicial rules would say it has to defer to the facts that are found below, and so I think that would constrain the Supreme Court in terms of how quickly they could make these big changes.
And you don't think that would be constraining in the normal process because they'll have the opportunity to hear and again, what you were talking about, just for listeners, right? You generally have which court has original jurisdiction. In the case of voting rights Act claims, it comes up one effectively in that hierarchical system for original jurisdiction.
Yeah, it goes to a three-judge trial court instead of a one-judge trial court, and then it goes straight to the Supreme Court instead of going to a court of appeals first. So it's a faster process, but it has been a fairly fact-laden type of analysis. But here the facts were found as they were found by the lower court, and the precedent supports the Supreme Court's precedent, and the facts in this case irrefutably support the ruling that came from the three-judge court in Alabama, which is why it was unanimous. I suppose the other part of it, besides the fact-finding piece, and I'm sorry to drag on, but if the Supreme Court wanted to, make changes in the doctrine, if it wants to actually gut all of the redistricting protections, which are the only part of the Voting Rights Act that it hasn't already gutted, Section 2, that is, of the Voting Rights Act, then it would have to have an ordinary schedule of briefing and argument. And so even if it wanted to do that this term, it probably wouldn't get the opinion out until June or July. And by then, it would definitely be running afoul of its own rules against interfering too close to an election. So if it wanted to, the Supreme Court interfered, but it interfered now. If it followed the ordinary procedural course, then even if it rules in favor of Alabama, it probably wouldn't be in a position to make that ruling take effect until the 2024 election.
Now, also, the Alabama case, although this is the one that this week is going to come up to the Supreme Court, is not, in fact, the only one dealing with this question of electoral maps. As a matter of fact, also this week in Florida, Governor DeSantis actually asked the Florida Supreme Court for an advisory opinion, which the court today refused to give, asking on the constitutionality of breaking up a long, about 200-mile long, but historically African-American district in North Florida for Representative Lawson. How do we think that some of these additional, again, maybe I'm looking at Florida more specifically because that's, once upon a time that's where I lived, but I know we have these elsewhere. What do we see as this pattern here when it comes to what states are thinking about in terms of districting for either of you?
Well, I could answer it again. I didn't know if Emily wanted to jump in.
No, you're good. I'm just kind of reading up on some things while I'm listening to all of you.
Okay. Yeah, so the states. Okay, I'll go for it then. So with the states, you have some different issues. In Ohio and in North Carolina, you've got state courts that are right now in postures where they've struck down their state legislative maps, and those state legislatures have to redraw. So we don't know what the maps are going to look like in Ohio or North Carolina yet. That's potentially the case in Florida also. The state Supreme Courts generally will make rulings based on their own state constitutions. Now, state Supreme Courts also can make rulings based on federal law. And if DeSantis in Florida had some concerns about compliance with the Federal Voting Rights Act, it wouldn't matter if the Florida Supreme Court gave him an advisory opinion on that because a federal court wouldn't have to defer to that. But in the cases in Ohio and North Carolina, the gerrymanders that were held unconstitutional were held unconstitutional under the state constitutions, not under any federal law. So in both of the states, that has to do with unique aspects of the two state constitutions, which are not applicable outside the state and which are not cognizable under federal law, which means the U.S. Supreme Court can't actually reverse those cases.
And that might be something historically, just to put into perspective here, right? The American system is one. The Constitution actually gives the right to determining how national elections will play out, primarily into the hands of state legislatures. But of course, Congress then later on will create some additional rules. Now, really the two biggest are you have the Supreme Court ruling in Wesbury v. Sanders, which says that every individual has to have approximately the same amount of kind of mathematical weight as any other voter, right? The one person, one vote principle. And so you get that as a constraint on states' ability to create their own national election rules. And then, of course, the second that you're talking about here, and that's really kind of the crux of what's happening in Alabama, is the Voting Rights Act, which then creates, especially for historically, for states that had historical issues with discrimination, would actually have to go through a court process. Because you had mentioned there, and you did it kind of in passing, Ken, so I thought it might be worth talking about. You were talking about the only piece of the Voting Rights Act that's really matters anymore. Maybe take us through that just a little bit, because that, I don't think everybody always recognizes, okay, states have the primary ability to create these national electoral rules, but then the Voting Rights Act constrains it some, and that has changed over time.
Yeah, well, okay. I can explain that. So I'll start with the text of the Constitution and then move a little bit into the history. So the text of the Constitution, as it was originally ratified in 1787, has in Article 1, Section 4, the rule about the allocation of power between state legislatures and Congress in terms of conducting congressional elections. And it says, so Article 1, Section 4 says, the times, places, and manner of holding elections for U.S. senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. So the Constitution presumes that that U.S. congressional elections will be conducted under rules that are made by state legislatures, but it has always said that Congress can alter any of those regulations anytime. So Congress can always make different rules and preempt state law on that.
They just simply often have not.
Yeah, well, sometimes they have. I mean, we have things, for instance, like a national election day, right? So states are not, states have never been free to set the time of elections.
True.
Congress has always said that'll be on the first Tuesday after the first Monday in November, and other kinds of things like that go way back. The 15th Amendment adds to that because after the Civil War, the 15th Amendment has two sections. So first, it says, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. So there can't be denials of voting right based on race anywhere or in any state. And also, the Congress shall have the power to enforce this article by appropriate legislation. So in addition to the power that Congress always had to alter or amend state election law, Congress has a specific power to enforce the rule that the states can't have voting discrimination by race or denials of the right to vote by race. So Congress has some extra discretion in deciding what that means and how to implement that. So based on that, it actually took 100 years, but after the 15th Amendment was ratified in 1870, it actually took all the way until 1965, so 95 years. But Congress did enact a pretty strong Voting Rights Act in 1965, and it was intended to make up for the fact that despite getting the 15th Amendment 95 years earlier, that in most sections of the country, as late as 1965, most African Americans couldn't vote because there were a lot of different kinds of restrictions that were preventing them from voting, Jim Crow type restrictions and others. And so the Congress in the Voting Rights Act of 65 did a few different things. And by now, the Supreme Court, since 2013, has gutted most of those things, but these were in effect from 1965 to 2013. So one thing that the Voting Rights Act does is it basically makes it illegal for states to use eligibility criteria for who can vote that have a disparate impact based on race, unless there's some extremely good reason for it. And so in principle, that means that there shouldn't be things like voter ID, because voter ID disproportionately burdens African American voting, and there's no good reason for it. But the Supreme Court has gutted those provisions of the Voting Rights Act and allowed voter ID to take place nonetheless. Similarly, the 1965 Act had a provision that only applied in certain states and actually in certain counties, and it was based on how many African Americans voted in the 1964 presidential election in that jurisdiction. So in jurisdictions where only 1% or fewer of African Americans were actually able to cast votes in the 1964 presidential election, extremely low number there. For counties and states where almost no African Americans could vote, fewer than 1% in 1964. Those jurisdictions were labeled as presumptively voter suppressing jurisdictions, and they were subject to a pre-clearance requirement where if they ever wanted to make changes to their districting or to their voting rules, they had to get pre-clearance from the Justice Department first, which had to rule that these were not done for the purpose of suppressing the black vote. And that is still part of the Voting Rights Act, but it was never repealed. But in 2013, the Supreme Court held that unconstitutional. So now that's what opened up the floodgates since then for these kind of things like you're seeing in Alabama, where they're able to go ahead and enact and presumptively implement a racial gerrymander without having to first get the permission of the Justice Department. Until 2013, they wouldn't have even been able to enact that statute, but without the Justice Department's sign off. And then the final thing that you still have now, which is I think what they're going to gut now, is Section 2 does still allow these challenges after the fact, right? So Alabama, although they didn't have to get the permission of the Justice Department first before they enact this racial gerrymander, even though the Voting Rights Act says that they should have to, it's still possible now, once they implement a racial gerrymander, for African Americans who are being disenfranchised by it to go to court and prove that they're being intentionally disenfranchised based on race, using certain standards that have been laid out in Supreme Court precedents. And if they can make that proof, then the Supreme Court can still, or the lower court or the Supreme Court, any court, could still find that the new map actually is a racial gerrymander and can't be allowed to take effect. So that's the proceeding that was used in the Alabama case now. That proof was made. That finding was made by a bipartisan court, but it seems that the Supreme Court, may have an agenda right now that's the one and only thing that they haven't already gutted in the 1965 Voting Rights Act, and they may be getting ready to gut these causes of action as well.
Now, I'm going to probably sound like a broken record on this to say, well, some additional, some context here, right? So you talk about the 1964 Voters' Rights Act and how in Georgia specifically, we have districts where you have minuscule African-American turnout. And I think for many, there isn't a real understanding of how recently some of those very strict barriers were for African Americans. So, for example, even into the 60s in Alabama, we had grandfathered literacy tests required in many parts of Alabama. One of the things I make my students in my Introduction to American Politics class do is take a piece of that test, and none of them would be able to vote on the basis of that test. And I think a lot of times we think of those kinds of segregation pieces as being something that was a long time ago, and it doesn't have kind of pragmatic implications. But of course, the 60s is just a couple decades removed from me being born, let alone. and you have this
exactly.
feelings. Yeah, Emily, anything you want to talk into that?
No, I'm good. I'm just kind of nodding along to everything that Ken has said thus far.
Well, why don't we take an opportunity to have a short break for an ad, and then we'll come back and talk about the National Archives and Trump. Okay, so let's come back. This week we had really some, it wasn't the kind of thing that I thought we'd be having a conversation about, but I oftentimes feel that way when it comes to Trump news. This week it came out that the National Archives and Records Administration retrieved 15 boxes of documents and other items from President Trump's Florida resort because they were not turned over when they were supposed to be back in January. The National Archives retrieved the White House records from Mar-a-Lago. And Trump, already one for potentially skirting the rules, has never seemed to take history seriously on that front, but has taken on potentially new heights. According to the NARA, the material should have come back in January, and that Trump representatives, even right now, are continuing to search for additional records. Some of the records that we've already had our hands on, at least that have been provided to the January 6th committee, for example, had appeared to be destroyed and put back together after the fact to kind of attempt to continue to comply with these laws. Now, there are some historic examples of presidencies who have taken things they weren't supposed to. Most recently, for example, the Clintons took a variety of furniture costing somewhere in the vicinity of $30,000 that they claimed were gifts, weren't really gifts, and had to be returned to the National Park Services. But individuals close to this say that although we've had those kinds of things happen before, that these kinds of boxes and documents are, in their words, at least, quote, out of the ordinary, end quote. Later this week, the story continued to develop as the NARA asked the Justice Department potentially to examine Donald Trump's handling of White House records. Now, of course, this matter is preliminary, and there's really no way for any of us to know what's happening on that front, other than that potentially has moved forward. Now, in a statement this past Wednesday, Trump said that he had a positive conversation with the NARA, and had arranged for, quote, transport of boxes that contain presidential records in compliance with the Presidential Records Act, end quote. There's Also, a little bit of an irony here, because of course, this is precisely one of the things that Hillary Clinton, on her most recent was potentially flaunting when she did not properly store her emails. Now, you might remember those because that was something that Trump repeatedly brought up against Hillary Clinton, something for which he had asked her to be jailed for. Now, additionally, in all of this, there is a possibility that some of these documents, these 15 boxes, contained things that included material that was classified, which also might be referred to the Justice Department. So, Ken, Emily, thoughts?
I'm just thinking from a purely historical standpoint, you just yikes, so much yikes.
In one word, yikes. Okay.
I'm having flashbacks to when they torched the Library of Alexandria, which no, I'm still not over, which isn't quite comparable, but still you're destroying valuable records. And it also kind of reminded me of Nixon and his editing, or someone's editing anyways, of all of the various tapes involved in Watergate. So I think they cut out a lot of Nixon's colorful language, and also possibly some evidence too. So yeah, that's kind of my take. Mainly, oh no, and we need to get them back, and for him to stop destroying things.
Ken?
Yeah, I think the violation of the Presidential Records Act here is unusually blatant and willful, even though, as you noted correctly, almost every president since the Presidential Records Act was enacted in 1978, but pretty much every president has had some technical violations of it and some small violations of it, and none have ever been prosecuted for that. And so, if any criminal prosecution is brought against Trump, it's obviously there's going to be accusations that it's political because nobody's ever been prosecuted under this before and people have violated this before. But I don't think anyone's ever violated it in quite as blatant and willful and really gleeful a way as Trump has. There's reporting today about this Maggie Haberman book that's going to come out that was saying that the maids and the janitors who work in the White House were constantly fishing pages that had been flushed down toilets out of the White House toilets. And, the National Archives, even in the stuff that wasn't squirreled away to Mar-a-Lago that they already had, they had a lot of documents where he had torn them up into tiny little pieces. And then later people collected up all the tiny little pieces and sent them to the National Archives. And they had a staff that scotch taped them back together. And, I think the sort of pattern and practice of really willful disregard for the Presidential Records Act does deserve criminal prosecution in my view, but I'm not holding my breath for that to happen.
No, I agree with you. I don't think there's going to be any kind of major push, in part because it's clear. I don't think, if you're the Biden administration, these things are already known. It's not going to change any particular buddy's vote position. There's not a lot to be gained, I think, politically, at least, from continuing to try to pursue these kinds of matters. I think you're right about that. But I do think at least it will make for those of us on the scholar side a fruitful future for trying to kind of think through why and what was handled the way it was. I mean, one possibility, of course, is this is just Trump's MO. This is what he's always done. And so being one who doesn't understand the rules or care about the rules, never even figured it out, and just continues a practice that he brings into the White House. Of course, the more nefarious possibility is that it's not just a practice that continues into the White House, but it was one, in fact, that is more targeted and designed to make it more difficult to understand what was happening in the White House during his tenure. Now, as a matter of fact, just a kind of an interesting historic and technological note, even George W. Bush did not send emails, neither did Clinton, or use a lot of digital communication, in large part because of questions about what they'd have to record and what would end up having to go over to the National Archives and Records Administration. And so your first email, I believe I'm getting this right, I think George W. Bush sent 3
Wow.
Yeah, it's not until you get to Barack Obama that's a big shift. As a matter of fact, Barack Obama would reorganize the Office of the President to include a social media, a formal social media element institution. Now that'll get changed later in his second term, and then as we get into Trump's administration, because again, social media is not kind of the hot deal that it was once upon a time in the same kind of way, thinking of it uniquely. So, but yeah, no, I mean, I guess there's not a lot to, maybe speculate there, but what do you guys think? Do you think this is more of a, kind of to put it back there, is this Donald Trump just, we see this as him, the personality, it comes in the White House, he doesn't care, know about the rules, and he's doing what he's always done? Or do you see this as being more purposeful?
Well, I think it's both. I mean, for one thing, it doesn't seem like much of a defense. Like if I'm driving 100 miles an hour down the highway and I get pulled over and I say to the cop, well, I mean, I always drive 100 miles an hour. That's not going to be a defense. So
okay, it's funny that you say that. And I don't mean to interrupt you, and I want you to finish that thought. But as a matter of fact, exactly 24 hours ago, I had a student say, and basically asked me that question. They're like, listen, I always speed. So if somebody pulls me over, couldn't I always say, like, listen, I've always gone down this road? And I had to say, no, that's not how that works. So it's really funny that you bring that up.
So I mean, I can certainly believe the facticity of the statement that he habitually, he learned back when he was a crooked businessman to always tear up everything, and it just became his habit to tear up every paper, and that's why he did it. But that's not a defense when he's under an obligation as president to preserve all the presidential records, which are in fact the property of the United States government, not his property. But also I think it is seeming to turn out, in addition to that some of the things that are missing, and I'll tie this back to what you said about email. Although it's true that Clinton and Bush didn't use email, they did talk on the phone. Their phone calls were not recorded, but their phone logs of what numbers they talked to and how long they talked to them were records that are part of their presidential records. Well, some of those kind of records are missing, particularly the ones from January 6th, right? So the logs of who Trump was talking to on the phone, at what times, and for how long on January 6th are among the missing documents. And, I don't think, I wouldn't put that down to just his ordinary habit of tearing up paper, because that's not the kind of paper that would have been on his desk to begin with. The records of what phone calls he made, that's something that he must have actually sought out and ordered to have made disappear or torn up. And that's I think that's a serious violation of, it's section 2071, if people want to look it up. Section 2071 of the U.S. Criminal Code, Title 18, makes it a federal crime punishable by up to 3 years for a person who has custody of a record. That person willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys the public record. I think there's a criminal intent there for some of these records that would not normally have even passed across his desk, that it wouldn't have just been within the normal course of his habit of tearing up paper to tear them up.
Well, let me put this in a broader question, then we can put this one to bed. One of the things that I have thought about in this term, you're talking about how Trump is kind of running roughshod over. I mean, he did all kind of criminal and other kinds of law. This brings me back to a book, and I'm not sure if either one of you guys are familiar with this, but back during George W. Bush's administration, there was a right-wing pushback to some of what was seen as being kind of the overarching uses of the presidency during the George W. Bush's administration. And most famously of this is a guy named Gene Healy, writes a book called The Cult of the Presidency. And he pushes back against the idea that we want to have big, powerful presidents, and that having big, powerful presidents are something that Republicans should be behind. And just for a little bit of a history lesson, he points to the fact that as you begin kind of with the Reagan administration, there's this Article 2 interpretation that says that the president's going to get a lot more power. And where that comes from is at the beginning of Article 1 and Article 2, there are these similar but slightly different worded phrases. In Article 1, there's this phrase that says all the legislative powers herein granted are delegated to the president, to the Congress. And then in Article 2, though, it says the executive power is to be vested in the presidency, and that ended up eventually being considered a grant of power. And what Healy and others were pushing against was to say, if you give that kind of power to presidents, what will eventually happen is that there's really no effective pushback from any of the other branches. And when I look at the Trump presidency, Ken and Emily, what I see is maybe some of Healy's arguments coming. I think, man, it was a good point. So here you have somebody pushing, violating these acts, but is there really any effective way to stop a president who violates the law regularly? And it seems to me the answer is no, and that the problem isn't just Trump. And I think one of the things I wonder about is, was the problem Trump, or was the problem that we've had an office that allowed a man like Trump to act the way he did? And I'm kind of curious about each of your takes on that.
I actually think that it's the second thing that you said. I think the assumption has been, for whatever reason, that we wouldn't, presumably that we would have more sense or whatever. I don't particularly like Trump, so that we wouldn't elect somebody who would exploit what looked to me to be like loopholes there, that nobody would come in and just take advantage of the fact that, as you said, who's going to tell the president no? And then we wound up with Trump, and here we are. But so I kind of think that it's more that the loopholes were there, and the assumption was that we would never have somebody that would exploit them, and then now we do, or did.
Ken, what do you think?
I probably actually would separate two things that I think you were linking a bit. So there's the notion that because at least since the Youngstown Steel case back in the 50s, the vesting clause of Article 2 that vests the executive power in the president has been seen as a kind of broad and independent grant of power to the president, and that has facilitated a great growth in presidential power. So that was one of your points, and you were kind of linking that to the idea that it's hard to hold the president accountable to law.
Yes.
I think those are two separate issues, so I wouldn't necessarily link them. Like I certainly agree descriptively that the modern interpretations of the vesting clause have shifted a lot of power to the president and made it much more powerful than it would have been before World War II, say. But I don't actually think that is the structural difficulty about holding presidents accountable to law. I think that if the real problem there is kind of more with politics, because I think that Congress has the tools, and the subsequent Justice Departments have the tools to enact laws that can be enforced against presidents, at least when they leave office, and sometimes while they're still in office, and to use them both to constrain the power of the president in certain ways while they're in office, and to hold them accountable through civil or criminal liability when they leave office. I think we have those tools already, and that if you don't see them being used, it's not because so for instance, on the one hand, you have the question, who can hold Trump accountable if he violated the Presidential Records Act and destroyed or stole all these records? Well, I would say, Congress passed the Presidential Records Act. Congress passed statutes that have criminal penalties for mutilation of public records. And the Justice Department can bring prosecutions under those statutes. And there's no doctrine that would give Trump any kind of immunity now that he's out of office. So I think despite the fact that, presidents are powerful, the legal tools are there for holding people accountable. And if that doesn't happen, I think that's a function of a defect in our political culture more than a defect in the laws. I see the growth of executive power under the Youngstown Steel doctrine as more being about not necessarily unleashing the president to do things that Congress thinks should be illegal, but just giving the president a little more power to respond to emergencies where there's not quite enough law on the books one way or the other to make it clear whether what the president needs to do is legal or illegal. And I don't see that as a terrible doctrine. So I actually think it's okay to have a robust conception of the presidency where the executive power includes broad powers to respond to emergencies when there's legal ambiguity. I think that's okay if it was side by side with a stronger political culture that would say when laws have actually been enacted into law that control the president's conduct and the president violates them, then even right while he's president, courts should hold those things illegal and make him stop doing it. And when he's not president anymore, if he's committed crimes, he should be prosecuted for them or sued for civil liability or whatever. I think we could have both. So I don't necessarily link the two things the way you did.
Okay. I mean, I guess I still would. I still think, politically speaking, to have the will, you have to have an institutional structure that balances. And I think that that post-modern understanding of the presidency is one in which Congress doesn't have as much effective pushback. And I'm just not sure, you point to the Justice Department, I'm just not sure that kind of framework is one that really would rein in presidential power. But I'm going to put a pause on that conversation because we have actually come to the end of our free ad-supported preview. And so, listeners, I want you to know that if you'd like to listen to the rest of this is available to our supporters. And you can hear the entire episode. We're going to continue our conversation. We're going to talk about ending the stock trades. We're going to talk about open market acts and more coming up. But that's going to be here after this preview ends. So if you want to become a supporter and become part of this, you can head to patreon.com/politics guys. You can also support us at PayPal at politicsguys.com/support or through Venmo, where we're at Politics Guys. Again, that's patreon.com/politics guys or at politicsguys.com/support for PayPal or through Venmo, where we're at Politics Guys. Now, if you're not in a financial position to support the show, but you would like to be part of that, you can reach out to Mike at politicsguys.com so that he can set you up with access to the full ad-free version each week. And you can take a look there at the other possibilities. There's additional levels of support and things you get, like joining us on Discord and more. So if you'd like to do that, you can, again, head to patreon.com/politics guys. The executive producers of the Politics Guys are Bruce Johnson, Wilma Marino, Andra Masker, Daniel Toe, Chris Wilkerson, and Ryan Beasley. I hope you'll continue and support us for the full show.